International Criminal Court is now in session, hosting the ICC Moot Court Competition 2016 English version. Please be seated.
I would like to greet the teams of the Counsel for the Government of Juncker and Counsel for the Prosecution and Legal Representative for Victims. I welcome as well the courtroom staff and the security officers who diligently assist us in all our work. I should also greet those in the public gallery. We're very grateful for the full attendance and the participants in the ICC Moot Court competition itself attending this hearing, and those outside the court who join us this afternoon on the internet. I would now turn to the court officer and ask that he calls the case, please.
Thank you. We are sitting in an appeal session regarding the situation in Porvos, ICC Moot Court Competition 2016 English edition.
On behalf of the chambers, I would now ask the parties and participants in this hearing to introduce themselves, beginning with the counsel for the government. But before you start, counsel, I would like to ask the parties and participants to speak slowly and to pause before responding to any question in order to allow all the participants to follow closely. Could I ask you, counsel for the government, to present the members of your team?
Honorable judges, my name is Ruben Dillmann and I appear today on behalf of the government of Juncker, and I'm assisted by my co-counsel Julian Zündorf.
Thank you. I now turn to the prosecution team. Could I ask you, counsel, to present the members of your team?
Good afternoon, Mr. President, Your Honours. My name is Vansha Jain, and along with my co-counsel, Ms. Isha Jain, I appear on behalf of the prosecution today.
Thank you. And finally, I turn to the legal representative for victims, and could I ask you, counsel, please, to present the members of your team?
Mr. President, Your Excellencies, my name is Saw Ting Shing, legal representative of the victims, and I'm assisted today by my co-counsel, Stephanie Wong.
Thank you. The team of the registry is represented today by the court officer Wilfred Ndungu, who is kindly assisting us. And finally, I would like to introduce the bench. To my right is Philip Ambach, to my left Mary Ann Power, and I'm Judge Howard Morrison, who will be presiding over this hearing. The Chamber will now proceed consecutively with the three issues shaping the subject matter of today's hearing. Being mindful of the public nature of this hearing, I would ask the court officer to please read the agenda established by the Appeals Chamber.
Thank you, Mr. President. This case arises out of allegations of war crimes and crimes against humanity committed on the territory and against the vessels of the state of Porvos by members of a non-state group calling itself Olmec State of Tivos and Juncker, OSTY. The states of Porvos, Tivos, and Juncker are located adjacent to each other on the west shore of the Sea of Mirth. Formed in 2010, OSTY is a religious-based organization committed to the goal of creating an autonomous region ruled by Olmec religious leaders comprising the southern portion of Juncker and all of Tivos. At the request of the government of Porvos, on April 10, 2015, the Office of the Prosecutor asked the pretrial chamber for authorization to formally open an investigation into whether the OSTY committed international crimes within the jurisdiction of the ICC by A, recruiting and using child pirates in attacks against Porvos vessels as a crime against humanity, and B, contaminating Porvos's water supply as a war crime under Article 8(2)(b)(4) of the court's statute. Since April 10, 2015, the pretrial chamber has received written requests from 450 perversion victims wishing to participate in the proceedings and has appointed a common legal representative for these victims. In its submission dated May 25, 2015, Counsel for the Government of Yunko raised several objections to the jurisdiction of the ICC with respect to this matter. Pre-trial chamber rejected these objections and decided to authorize the prosecutor to open an investigation. The appeals chamber seeks submissions of all parties and participants on the issues raised before the pre-trial chamber, namely, A, whether recruitment and use of juvenile pirates by a non-state organization under the facts stipulated in this case can be tried as a crime against humanity within the jurisdiction of the ICC under Article 7 of the ICC statute. B, whether a non-state organization's cross-border contamination of a state's water supply, resulting in over 3,000 cases of illnesses, can constitute the war crime under Article 82b4 of widespread, long-term, and severe damage to the natural environment, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated under the facts stipulated in this case. C, whether a judge who wrote a passage in a book when she was a law professor prior to appointment to the ICC that opines on the issue of whether recruitment and use of juvenile pirates can be tried by the ICC as a crime against humanity must be disqualified from the pre-trial chamber in this case under Article 41 of the court's statute.
Thank you very much, Court Officer. I now give the floor to the Government's Counsel to present its case and to discuss the 4 issues on the agenda of this hearing. Thank you.
Honorable Mr. President, distinguished members of this court. The situation in Porvos brings the International Criminal Court to a crossroad. It is a chance for this court to set a signpost for the future of international criminal law. It is a chance for this court to create a clear boundary between international core crimes and crimes under domestic jurisdiction. And finally, Your Honours, it is a chance for this court to show that it respects the will of the states and condemns only the crimes of the most serious nature and of the most serious concern to the international community as a whole. Your Honours, I, Ruben Dillmann, assisted today by my co-counsel Julian Zündorf, appear on behalf of the government of Juncker on this appeal. And the government of Juncker kindly and humbly asks this appeals chamber to reverse the decision of Pretrial Chamber 6 for material and procedural errors. In light of this, we make 3 arguments, or we make 3 submissions. Firstly, recruiting and using juvenile pirates for piratical purposes does not amount to a crime against humanity. Secondly, the release of contaminants into Mirror Lake does not amount to a war crime. And thirdly, the Honorable Judge Hasty must be disqualified from the bench of the pretrial chamber. If it pleases this court, I would like to begin with the first issue on crimes against humanity. On this issue, we make 2 arguments. Firstly, the Olmec State of Tüvös and Juncker is not an organization as required by Article 7.2a of the Rome Statute. And secondly, it is also the attack in this case does not constitute an attack against a population, as also required by Article 7.2c of 7.2a of the Rome Statute. Regarding the first argument, the organization, we are aware of the broad approach and the broad construction taken by the pretrial chamber in the Kenya case. And we are aware that both of our learned friends and colleagues from the Office of the Prosecutor and the representative of the victims will confidently rely on this approach. Yet, Your Honours, we submit that this confidence is in fact inappropriate. This is because it is based on an erroneous decision. And therefore, I will show in the first step the errors of this decision that were in part also pointed out by the Honourable Judges Cowell in his dissent to the decision and the recent concurring opinion of the Judge Ozaki in the Bemba case. And after I have shown the errors of this decision, I will proceed to present a different approach based on the specific injustice of crimes against humanity. Regarding the errors of the pretrial chamber decision, we submit that the pretrial chamber 2 in the Kenya case created a loophole for the arbitrary interpretation and hence application of the law. And as a result, or the reason rather, for this loophole is that they created a vague case-by-case test. And this means that the court authorized itself by this decision to change its understanding and to change its application of crimes against humanity also case by case. And therefore, Your Honours, we submit that there is a lack of a clear concept of crimes against humanity. And still, Your Honours, still, such a clear concept has not been provided for by this court. And this is why, in a second step, I would like to present such a clear and succinct concept of crimes against humanity. In a first step to the second point, I'll show what this approach is. I will characterize and elucidate on this clear approach. In a second step, I will show what that approach means to the situation in Porvos. So, firstly, Your Honours, the specific injustice, the object and purpose of crimes against humanity as a whole is to penalize the abuse of political power. When an entity entrusted by a population with political power, with political control, turns against that population and attacks it instead, and neglects this duty, then the specific injustice of crimes against humanity arises. And only then the object and purpose of crimes against humanity comes into play and is realized. And this is why, Your Honours, we submit that only states or state-like entities are entrusted with the duty to protect this population. And only states or state-like entities can commit crimes against humanity. And this must mean, for the word organizational in Article 7, that only state-like organizations can commit such crimes. And this leads me to my second step, what that means for the present case. A state-like organization, Your Honours, is an organization that has control over territory, firstly, that has, secondly, a large-scale governmental and administrative authority, and thirdly, finally, most importantly, a monopoly of force it has been entrusted with by a population. And in the present case, especially this monopoly of force is lacking in OSTY. This is because the people of both Tuvos and Juncker are fighting this organization and are turning against the organization. And additionally, the Olmec state of Tuvos and Juncker, regardless of its name, has been characterized internationally as a band of pirates and as a criminal gang.
Counsel, if I may interrupt you here. Quick question. From the facts of the case, is it not also true that this group that you're referring to has undisputed territorial control? To my knowledge, there is no active fighting in any of the countries against this group, which would therefore speak towards this group having a rather undisputed control. So I'm asking myself where you take the elements from that you're making reference to right now. Thank you.
Jonas, to this our response is in two steps. Firstly, regarding the factual situation. We agree that OSTY might have territorial control somewhere, but still, the citizens of Tuvos in Querth are fighting the Olmec state and withstanding their siege with all their power. And still we, in Yankel, as a sovereign state, are using all of our police forces to work against the Olmec state and to defeat the Olmec state of Tuvos and Juncker. And secondly, Your Honours, regarding the monopoly of force, we submit that especially this means that the people have not entrusted OSTY with the duty, with political power over them, and therefore OSTY cannot abuse political power. And this approach, the reason why this approach is necessary stems from both eminent scholars and customary international law, Your Honors. So these three elements are supported by the fact that the Tadic judgment has found that under customary international law, only state-like entities can commit crimes against humanity. And Your Honors, there is no state practice, no hard state practice that would give rise to a different interpretation that would include anything else but state-like organizations. And consequently, the use of the simple term organization indicates that the drafters wanted the term to be interpreted in light of and along with customary international law. And as customary international law requires state-like organizations, we submit that in the present case, there is no organization as required by Article 7. Therefore, Your Honors, we would like to finally point out the merits of this approach are, aside from the fact that it respects customary international law, regarding the two other important values of legal certainty, of the legality principle, and of the sovereignty of the states. The merits of this approach are that it is the only approach that gives crimes against humanity a clear concept, a clear notion, and most importantly, Your Honors, a boundary. So with this concept, it is possible to distinguish between international core crimes and other crimes under domestic jurisdiction. And this, Your Honors, leads me to the conclusion of my first argument, that there is no state-like organization in the present situation, and therefore the Olmec state of Tübingen and Juncker cannot commit crimes against humanity. The second argument on the first issue that I will now take you to refers to the population that must be under attack, or the population that the entity in question must have attacked. Your Honors, Article 7 of the Rome Statute, as opposed to Article 6, which requires a group, requires a population to be under attack. And from the ordinary meaning of the term population, this must be a group, this must refer to all the inhabitants of a particular place. And therefore, it implies a certain numerosity. And this necessity for a numerosity has also been pointed out by our learned friends from the prosecution in their report on the situation in Honduras, where they refer to the necessity for a large-scale group to be under attack to amount to a population. And in the present case, the crew members of Porvos are a part of the Porvosian population that is physically separated only for a very limited period of time from the rest of the population. And a small part of a general population, Your Honors, is no population on its own. And similarly, for the juvenile pirates, they are a very small fraction of the adolescents in both Tübingen and Juncker, and this means that they are a part of a population. And therefore, again, they cannot be a population on their own. And therefore, Your Honors, no population was attacked by OSTY, and a second crucial element for crimes against humanity is lacking in this case.
Counsel, at this point, one question. Imagine you were to look at the more global confines of this conflict and you were to add, say, the attack or the poisoning of the waters into the confines of the attack against the civilian population. Would you not come to a different conclusion than having all of a sudden thousands of civilians that are suffering? Number one. Number two, could you back up with jurisprudence your finding that the population needs to be at such a large scale as you purport? Thank you.
Your Honors, on the first concern, on the first point, or rather, firstly on the point of the population, we respond that the jurisprudence in this case, or the question of what a population precisely is, has not been dealt with at the ICC so far, in the sense that there was a problem regarding this element. But we still submit that in all the situations involved at the International Criminal Court, the number of victims of the crimes against humanity was higher. And this leads me to your first question, The number of victims in this case could be raised, of course, if one were to include the victims of the war crime. But most crucially, they are not the victims of a crime against humanity, but of a war crime. And these appeals proceedings are to be considered victims of that crime only, and therefore do not change the numerosity of the population under attack in the question of crimes against humanity. And this, Your Honors, leads me directly to my second issue on the commission of war crimes. On this we make three arguments. Firstly, there is no international armed conflict between any of the actors involved. Secondly, the thresholds of Article 8(2)(b)(4) Rome Statute are not met. And finally, the ICC has no territorial jurisdiction over the commission of war crimes in this case. On the first argument, Article 8(2)(b) Rome Statute requires an international armed conflict for the crimes in this subsection. And an international armed conflict occurs only when there is resort to violence between two or more states. This is shown by both codified and customary international law. Regarding the codified international law, the common Article 2 to the Geneva Conventions and the additional Protocol 1 necessitate that there be two or more states in an international armed conflict. And regarding the customary international law, the Lubanga, the Katanga, the Bemba, and the Tadic judgment have unanimously found that the custom is that an international armed conflict must be between two or more states. And as OSTY is no state in the present case, and has been considered a non-state actor in the submissions of this chamber to the participants, we submit that there is no state and there cannot be an international armed conflict involving the Olmec state of Tirol and Juncker involving OSTY. And this leads me to the commission of the war crimes, to the alleged commission of war crimes by the release of contaminants into Mirror Lake.
Excuse me, Counsel, to stop you here. What would you make out of the potential argument that since your government hosts or sort of has this armed group operating on its territory, sort of through your inaction, sort of you have to be associated with its actions, and therefore we would have you or your country as a state involved in that conflict? What would you say to that?
Jonas, to this question, we would like to respond as follows. It is indeed possible to have an international armed conflict because the actions of a non-state actor are attributable for a state. But under international law, the two tests that have been raised for this are the effective control test by the ICJ and the overall control test by the ICTY. And we submit that in the present case, none of these two tests are met, since we as a sovereign state are doing everything we can to act against OSTY and do not support, finance, equip, or control them in any way. And Your Honors, on the commission of war crimes, the wording of the provision has been taken from Article 8(2)(b)(4), from the additional protocols, the Articles 35 and 55. And that the drafters copied the wording directly means that they intended an interpretation in light of these provisions. And this leads me to the submission that the term long-term must mean that the damage is to be measured in decades. And in the present case, the damage lasted only for 3 weeks. And even if one were to look at the potential damage the attack could have caused, there is no salmonella outbreak known in history which is to be measured in decades. And as the test between these three elements are cumulatively, or have to be fulfilled cumulatively, we submit that no war crime occurred by releasing contaminants into Mirror Lake.
If I could just ask you one question about that, Counsel. Would the loss of civilian life in itself not be sufficient to establish a war crime, in your view, in these circumstances?
To be honest, we understand this concern, but still we submit that in the present case, according to the submissions of the appeals chamber, we are dealing with the second alternative regarding environmental damage only. And while the loss of civilian life might be included in the first alternative of the norm, we focus on the second alternative. But even if there was loss of civilian life, as there is no international armed conflict, still Article 8(2)(b)(4) is not satisfied. I hope that answers your question, Jonas. And now, allow me to quickly summarize my point on the territorial jurisdiction so that I may proceed to the third issue. On this point, we submit that Article 12(2)(a) requires the conduct to occur on the territory of a member state. And this crystal clear wording requires precisely that only the conduct can occur in the territory of a member state, and not the consequences and not the circumstances. Because Article 30 of the Rome Statute divides a crime cleanly into these three elements. And this must mean that the drafters intended that only when an act or omission occurs on the territory of a member state, there is territorial jurisdiction of the ICC. And in the present case, the relevant act under Article 82b4 is the launching of an attack, which did not occur in the territory of Porvos, and therefore the ICC has no territorial jurisdiction. This leads me, if there are no further questions on this issue, Your Honours, to our third and final submission. Regarding this, we submit that Judge Hastie must be disqualified from the bench of the pretrial chamber. The test for the disqualification of a judge brought up or was formulated by the ICC in the al-Bashir case and stemmed from the Furunjia case at the ICTY. According to this test, a judge must be disqualified if he or she appears biased to a reasonable and well-informed observer. And bias, according to Judge Bergenthal at the ICJ, means a state of mind in which the judge can be deemed to have prejudged one or more of the issues in question. And the crucial reason why we submit that Judge Hastie has prejudged this issue is her advocation of her opinion by the use of the word heinous. This word is used by the preamble of the Rome Statute and eminent scholars to characterize the core crimes under Article 5. And therefore we submit that her writings mean that she argues that the recruitment of and use of juvenile pirates is indeed a crime against humanity. I would like to bring to the attention of this court that the only difference between the situation in Somalia she wrote on and this situation are the names. And therefore, she must be deemed to have prejudged the issue at hand and is therefore biased and must be disqualified from the bench in this case. And if there are no further questions, this leads me to the summary of my arguments.
Just one. Don't you find it possible to draw a distinction between academic comment and the duties incumbent upon a judge to examine the evidence and only reach a reasoned conclusion on the evidence? There are seems to me, two quite separate strands there.
Your Honours, to this concern, we would like to respond that Article or Rule 34 of the Rome Statute specifically mentions expressions in writing as a ground for the disqualification of a judge. And as these expressions in writing prior to her being a judge count as a possible ground for disqualification, and as we have shown, there is bias in her for an objective and reasonable observer. If you would allow me to quickly finish this submission, Your Honours. Thank you very much. Therefore, we submit that Judge Hastie must be disqualified. And in total, this means we submit that recruiting and using juvenile pirates is not a crime against humanity. The contamination of Mirror Lake is not a war crime. Judge Hastie must be disqualified from the bench, and therefore, in total, we very respectfully ask this appeals chamber to reverse the pretrial chamber's decision. If there are no further questions, Your Excellencies, we thank you for your attention, and with this, we rest our case.
Thank you. I now turn to the prosecution to present its submissions on the same four issues of the discussion. Thank you.
Our case today is simple. There is ample evidence to prove that OSTY has committed atrocities against Porvosian civilians and on-board Porvosian vessels between June 2014 and March 2015. It is the job of the Office of the Prosecutor to investigate these atrocities and to bring those responsible to justice. At this point, we are merely requesting this court to allow us to do our job in investigating this situation. We are not issuing an arrest warrant. We are not confirming charges. We simply want to find more information. Thus, we would ask this court to confirm Pretrial Chamber 6's decision, as it does not suffer from material error. We would also remind this court that the standard of proof for the prosecution in this appeal is extremely low. all that must be shown is that there exists a reasonable basis to proceed with the investigation. Your Honours, in my submissions, I will be responding directly to the objections raised by the Government Council. I will first address the preliminary issue, which concerns the disqualification of Judge Hastie. I will then address the merits and argue that the recruitment and use of juvenile pirates is a crime against humanity and that the contamination of Mirror Lake is a war crime. With your permission, may I begin with my first submission? Thank you, Your Honour. Your Honour, in 2011, Judge Hastie authored a book titled Emerging Issues in International Criminal Justice, in which she observed that the recruitment and use of juvenile pirates could be tried as a crime against humanity by this court. The Government Council has relied on this statement to request her disqualification. However, we submit that this request must be denied for two reasons. First, the Government Council does not have legal standing to make this request. And second, that in any event, the statement made by Judge Hastie does not warrant disqualification. Beginning with the first, that the Government Council does not have legal standing. If Your Honours would consider Article 41(2)(b) of the Rome Statute, it clearly lays down the parties that are entitled to request the disqualification of a judge. It grants this right to the prosecutor and to the person being investigated or prosecuted. In fact, as Professor Shabis has observed on page 569 of his book, The International Criminal Court, a Commentary, a proposal to include interested states such as Juncker within this provision was specifically voted down because the drafters of the Rome Statute felt that this would cause unnecessary interruptions in the functioning of the court. Moreover, in 2014, a plenary of this court, in the Katanga case, while determining the disqualification of Judge Wingard, ruled that Article 41(2)(b) had to be read in a strict fashion and that only those parties specified in it and no others would be permitted to request the disqualification of a judge. Therefore, we submit that Government Council clearly lacks legal standing to make this request. In any event, we submit that the statement made by Judge Hastie does not warrant disqualification. Your Honours, as this court has noted on several occasions, there is a strong presumption in favour of the impartiality of a judge. In order to rebut this presumption, a party must provide evidence that firmly establishes the possibility of bias in the mind of a reasonable observer. This is ordinarily done by showing that a judge has a personal or pecuniary interest in the matter before them. We submit that the mere publication of a moderately worded academic opinion is simply insufficient to create a similar apprehension of bias. This was made abundantly clear by the ICTY in paragraph 203 of the Furunzija judgment, where the court found, in essence, that a reasonable observer would only expect a judge to have an open mind, but not an empty mind. In that case, the court observed that a fully informed, reasonable observer would be aware that it is practically impossible for a judge to be perfectly neutral on all issues that come before them, and that a judge would have certain personal beliefs about the issues that they hear. Therefore, they held that the mere proof of such a personal belief would be insufficient to warrant the disqualification of a judge. Rather, what must be shown is that the personal belief is of such a strength or such a nature that it proves that the judge has closed her mind on the issue and prejudged the issue. We submit that that is not the case with Judge Hastie's opinion because of the moderate tone that she has used, and she has stated that the recruitment and use of juvenile pirates could someday be tried as a crime against humanity by this court. The inconclusive nature of this statement and the moderate tone that she has used indicates that she should not be disqualified. If Your Honours have no further questions on this issue, I will proceed to my second submission, which concerns...
Just have one quick question. You've cited a lot of jurisprudence from the ICTY and the ad hoc tribunals. Are you asking us to base ourselves on this jurisprudence in order to make a finding in
Your
relation
Honour,
to this issue?
Certainly. Your Honour, as this court has noted in the authorization for investigation in Kenya, this court is entitled to look at the jurisprudence of other international tribunals. Moreover, because the test adopted for the disqualification of a judge in the ICTY is exactly the same that this court has adopted in Prosecutor versus Lubanga, we submit that that jurisprudence is persuasive for this court's finding. Proceeding to my second submission, which concerns the recruitment and use of juvenile pirates. In June 2014, OSDY launched a series of piratical attacks against Porvosian aid vessels in which they used 1,000 juveniles who were under the age of 14. Approximately half these children were killed in the attacks. The Government Council questions whether this act of recruiting and using juvenile pirates can be tried as a crime against humanity by this court. We submit that the answer to this question is yes, for 3 reasons. First, the crime of enslavement has been made out, and the consent of the parents does not preclude the commission of this crime. Second, the number of child pirates in the present case satisfies any numerosity requirement under Article 7. And finally, third, that OSDY is an entity that is capable of committing crimes against humanity. Beginning with my first submission, that the crime of enslavement has been made out. Your Honours, it is our submission that the recruitment and use of juvenile pirates constitutes the crime of enslavement under Article 7.1c of the Rome Statute. According to the Elements of Crime, page 6, footnote 11, the crime of enslavement includes any conduct that is specified in the Supplementary Convention on the Abolition of Slavery. Article 1d of the Supplementary Convention states as follows: the delivery of a child for the purposes of exploitation by either or both of his natural parents to another, whether for reward or not, constitutes enslavement. Your Honours, we submit that all these requirements have been met in the present case.
Counsel, one question here. The moment that the parents hand over their child to the authorities, on which territory would that happen? And how
Certainly.
could that be relevant to us here right now? Thank you.
I understand your question, Your Honour. While it is true that the parents in this case handed over the juveniles on the territories of Taivosh and Junkel, we submit that the offence of enslavement is a continuing one, and therefore, because the offence continued onto Porvosian vessels when these juveniles were used in the attack on those vessels, this court does have territorial jurisdiction. This is because under Article 12.2a, this court does have jurisdiction over crimes committed on board vessels that are registered to state parties, and Porvos is a state party in the present case. Your Honours, we further submit that the consent of the juvenile's parents in the present case does not preclude the commission of this crime of enslavement, and this is because under Article 21.3 of the Rome Statute, this court must interpret the crime of enslavement in a manner that is consistent with existing human rights standards. One such standard is provided under Article 18 of the Convention on the Rights of the Child, which states that parents can only give consent on behalf of their children when such consent is in the best interests of the child. We submit that it would be an absurd interpretation if this court were to find that parents are entitled to consent to the exploitation of their children, as this is not in their best interests. For these reasons, we submit that the crime of enslavement has been established in the present case.
Would you go so far as to say that it is impossible to give consent for someone else to commit an offence, regardless of their age?
Your Honour, this court itself held in Prosecutor versus Lubanga that when a person is in a position where they are vulnerable or unable to give consent, that consent would not be relevant for the determination of whether the crime has been established. In the present case, what we are concerned with are children who cannot possibly understand the consequences of their decision, and therefore the consent of the child should not be relevant. Further, as I have established, the consent of the parents is also not relevant because, as per the wording of Article 1b of the Convention, of the Supplementary Convention on the Abolition of Slavery, and in light of Article 18 of the Convention on the Rights of the Child, parental consent should not extend to allowing the children to be exploited. Proceeding to my second submission, that the requirement of numerosity under Article 7 has been met. The Government Council has argued that the number of child pirates in the present case is insufficient to satisfy the numerosity requirement under Article 7. Your Honours, we have found 13 decisions of international courts and tribunals where the presence of hundreds of victims was considered sufficient to establish a crime against humanity. If Your Honours would consider paragraph 7 of the facts, it clearly states that 1,000 juveniles have been the victims of OSTY's attack. In fact, in the Kenya case, an identical number of victims was considered sufficient by this court to establish an authorization of investigation into crimes against humanity. Therefore, we submit that the number of juvenile pirates is adequate to satisfy a numerosity requirement. The Government Council argued that the number of juvenile pirates is also insufficient in terms of the total population of Yunkel and Taivosh. However, we submit that the combined population of Taivosh and Yunkel is 2.5 million. In the case of Kenya, the total population of Kenya was 45 million, and in that case, the presence of 1,100 victims was considered sufficient to authorize an investigation into crimes against humanity. Therefore, even in terms of a proportion to the total civilian population of Taivosh and Yunkel, we submit that the number of juvenile pirates is sufficient for any numerosity requirement.
Counsel, one question here. If we agree that the relevant commission of a crime for us here would be the attack of the vessels, isn't it true that at this point of time the child pirates that are being used are no longer victim civilians, but maybe rather some sort of fighters being used by the aggressing party?
With respect, Your Honour, I would disagree. And this was made clear in paragraph 615 of Prosecutor versus Tadic. In that case, the ICTY held that the determination of a civilian status of an individual was to be made at the time the crime commences. And in this case, the time the crime commenced, which was the time when the juveniles were recruited, at that point, the juveniles were civilians, and therefore they would retain their civilian status throughout the commission of these crimes, as per the decision in Tadic. Proceeding to my final submission, which is that OSTY is an entity that is capable of committing crimes against humanity. Your Honours, Article 7.2a of the Rome Statute states that in order for an entity to commit crimes against humanity, it must possess a state or organizational policy. This court, in the Kenya case, in the authorization of investigation, clarified that there are certain indicative features which show whether an organization meets the requirements of Article 7.2a. These criteria include the possession of the position of effective control over territory, as well as possessing the means to commit a widespread or systematic attack. We submit that both these requirements have been met in the present case. The facts are clear that OSTY has controlled the territory of Taivosh for nearly 2 years. Moreover, by possessing arms worth millions of dollars and having a membership of 50,000 individuals, we submit that they also have a capability to commit widespread or systematic attacks, as they did, in fact, upon the juveniles in this case. Finally, the Government Council has argued that the case in Kenya laid down an incorrect decision because according to the Government Council, the test laid down in Kenya varies as per the facts of each case, and this would violate the principle of legality. However, we disagree. The test laid down in the case of Kenya would remain consistent in each case. Rather, what would change is the determination on facts of whether an organization meets this test or not, and thus the definition of an organization would always remain consistent and would therefore not violate the principle of legality. Therefore, we believe that this court should apply the decision in the Kenya authorization for investigation case. If Your Honours have no further questions on this issue, I will proceed to the final issue, which concerns the contamination of Mirror Lake. Your Honours, when OSTY's attempts to block Porvos's aid through acts of piracy failed, they turned to far more sinister means. They contaminated the rivers that supply water to nearly half the population of Porvos, a population of 1.4 million. This caused an outbreak of salmonella-related disease, which led to 3,000 cases of illness and 50 deaths. The Government Council questions whether this act can be called a war crime under Article 8(2)(b)(4) of the Rome Statute. We submit that it can, and this is for two reasons. First, the crime took place in the context of an international armed conflict, and second, the damage caused was widespread, long-term, and severe. Beginning with my first submission, that the crime occurred in the context of an international armed conflict. Your Honours, an international armed conflict is defined as the resort to armed force between two states, and the Government Council has argued that since OSTY is not a state, its conflict with Porvos cannot be termed an international one. However, as the ICJ noted in paragraph 219 of the Nicaragua judgment, a conflict can also be termed international if it involves a non-state actor whose actions can be attributed to a state. Moreover, the International Law Commission, on page 39 of its commentary on the Articles of State Responsibility, notes that if a state fails to prevent reasonably the conduct of a private party acting within its territory that happens to be unlawful in terms of international law, that conduct can be attributed to the state. This, of course, amounts to the obligation of due diligence, and we submit that the obligation of due diligence is extremely high in cases of cross-border terrorism. As numerous United Nations resolutions have observed, these obligations include preventing the use of funds or financial assets for the use of terrorism, preventing the use of flagged vessels for the purpose of terrorism, preventing the supply of arms to terrorists, and finally, prosecuting terrorists. In the present case, UNCEL has failed to comply with all these obligations. In fact, a 2014 United Nations High Commissioner for Human Rights report observed that UNCEL has a weak and corrupt government that has been unable and unwilling to stop the OSTY threat. When Lebanon displayed a similar unwillingness to control the attacks of Hezbollah against Israel, the United Nations Commission for Inquiry considered this sufficient to attribute the conduct of Hezbollah to Lebanon and to term the conflict between the two an international one. In precisely the same manner, we submit that the conduct of OSTY can be attributed to UNCEL, thereby creating an international armed conflict between Porvos and OSTY. If Your Honours have no further questions, that brings me to my final submission, which is that the contamination in the present case was widespread, long-term, and severe. Your Honours, in order to commit the crime under Article 8(2)(b)(4), the damage to the natural environment must be widespread, long-term, and severe. I would like to reiterate at this point that the prosecution is not required to conclusively prove that each of these requirements has been met. Rather, what we are required to show is that there exists a reasonable likelihood that these requirements have been satisfied.
Counsel, before you get to these points, if I'm not mistaken, the conduct
Certainly.
might not have, again, occurred on a state party territory. So how do we deal with that in particular in light of Article 30? Thank you.
Thank you, Your Honour. It is our submission that although the conduct in this case took place in the territory of UNCEL, by virtue of the objective territorial principle, the crime can be deemed to have been committed in Porvos because its consequences were felt in Porvos, because of the contamination of Mirror... If I may complete my answer. Because of the contamination of Mirror Lake and the sickness that has been caused to the civilians in Porvos. As is made clear on paragraph 28 of the Assembly of State Parties Working Group on the Crime of Aggression, the principle of objective territoriality is implicit within Article 12(2)(a), and that the word conduct in that provision must be read as crime to include the consequences of the conduct. For these reasons, we submit that the crime did occur within this court's jurisdiction. If I may be of no further assistance, I thank this court for its time.
Thank you very much. After hearing from the government and the Office of the Prosecutor, the representative of the victims shall now present to the Chamber its arguments. If you please proceed, thank you.
Mr. President, Your Excellencies, may it please the Court. My name is Saw Ting Shing, and I've been appointed by the pre-trial chamber to act on behalf of 450 perversion victims. About half of these victims were perversion crew members who have been injured, who have been taken hostage for ransom by OSTY's pirates. The other half, ordinary perversion folk, have suffered illnesses as a result of an armed conflict they played absolutely no part in. In these circumstances, I'm here to let their voices be heard. And I make 3 submissions. First, that OSTY's recruitment and use of juvenile pirates is a crime against humanity under Article 7. Second, OSTY's contamination of Mirror Lake is a war crime under Article 8(2)(b)(4). And finally, Judge Hastie need not be disqualified as Her Excellency did not show an appearance of bias. Turning to issue 1. A crime against humanity under Article 7 occurs where any of the acts under Article 7(1) is committed within the context of a widespread or systematic attack directed against a civilian population. Now, I note Your Excellency asked the prosecutor whether the juveniles here were civilians, and if they were not civilians because they took up arms, whether an attack can be said to be directed against the civilian population of juveniles. In our submission, this need not be a concern, because our characterization of the attack directed against the civilian population is that this attack was directed against the perversion crew members. And this is allowed under the scheme of Article 7. Because an attack directed against a civilian population is defined under Article 7(2)(a) as a course of conduct involving the multiple commission of acts under Article 7(1). And one of these acts, the relevant act here, is the act of imprisonment under Article 7(1)(e). We submit that the attack directed against a civilian population was the civilian population of Porvos here. Turning to an objection raised by government counsel.
If I could ask you one question about that. I understand that the relevant crime is the recruitment and use of the children who are pirates. Are they not the relevant civilian population in that context for that crime?
Your Excellency, the definition of a crime against humanity is where any of the acts under Article 7(1) take place within the context of a widespread or systematic attack. The widespread or systematic attack here in our submission is the attack directed against perversion crew members. And the act that occurs within the context of this attack is the act of enslavement, which involves the recruitment and use of juvenile pirates. And this is supported by the authority of the Kenya authorization decision, for instance, where it is stated, and I quote, that the only requirement is that there be a nexus between the individual act and the relevant attack. And here we submit that the nexus exists because the juveniles were recruited and used to commit attacks against the civilian population of Porvos crew members. Turning to government counsel's objection that the attacks here were not conducted pursuant to an organizational policy. Now, the prosecutor stated and relied on this court's Kenya authorization decision to show that OSTY is an organization within the meaning of Article 7(1). We wholly agree. And we further add that with respect to the authorization of an investigation, where the relevant standard of proof is only that there be a reasonable basis to believe that crimes within this court's jurisdiction have been committed, this court's past jurisprudence has been to find that the organizational policy requirement is satisfied so long as the nature of the attacks seem organized, coordinated, and follow a strategy. This can be seen from paragraph 121 of its Kenya authorization decision, paragraph 100 of this court's Côte d'Ivoire authorization decision, and most recently at paragraph 20 of this court's 2016 Georgia authorization decision. We submit that on the facts of our case, the evidence of an 8-month period of systematic attacks conducted against Porvos flag vessels is sufficient evidence for the prosecutor to satisfy the relevant standard of proof. Now, I further note that government counsel has argued that state-like organizations are required for this organizational policy requirement to be fulfilled. And the organization here has to have been entrusted with the duty of protecting the civilian population. However, if we were to take government counsel's argument to the extreme, a tyrannical regime that comes into power through a coup and has absolutely no trust, has not been entrusted by the civilian population with a duty to protect them, that tyrannical regime will never be able to commit crimes against humanity. In our submission, the only authority that we are aware of that says that the organization requirement has to be sufficiently state-like is that of Judge Call's dissenting opinion in the Kenya authorization decision. But what Judge Call wanted to guard against were organized crime, mobs, and gangs of armed civilians falling within this court's jurisdiction. And if I may quote a paragraph 52 of Judge Call's dissenting opinion, Judge Call stated, and I quote, "Violence-prone groups of persons formed on an ad hoc basis, randomly, spontaneously, for a passing occasion, with fluctuating membership and without a structure and level to set up a policy are not within the ambit of the statute." And so even if we apply Judge Call's approach to the organizational policy requirement under Article 7, we submit that OSTY would still satisfy the relevant organizational policy requirement, because OSTY is clearly not an organization formed or a group of persons formed on an ad hoc basis with fluctuating membership. Turning then to my next submission on the civilian population in this case. Now, as the prosecutor earlier argued, the civilian population in this case need not be so high of a number, and we have a specific case to support this position. I refer, Your Excellencies, to this court's Katanga confirmation of charges decision at paragraph 412, for instance. In that case, the perpetrators conducted an attack on Bogoro village, which resulted in 200 deaths of civilians. Bogoro village consisted of about 800 people living there. And this court found that there was an attack directed against the civilian population of Bogoro village. In our submission, the 550 Porvosian crew members does satisfy this population requirement. With Your Excellency's leave, I turn now to issue 2. The first
Excuse me,
requirement.
Counsel. Let me just interrupt you there, because we haven't yet talked at all about widespread or systematic. If you could just give us a quick idea on what you think we're looking at. Thank you.
Certainly, Your Excellency. I note that under the Rome Statute, the widespread or systematic requirement is disjunctive. And our position here is that the attacks were systematic. This is sufficient, Your Excellencies, for this court to find that there's a reasonable basis to believe that a crime against humanity has been committed. Turning to issue 2, a preliminary requirement under issue 2 is that this court must have territorial jurisdiction. This has been sufficiently covered by the prosecutor, and I propose instead to deal with the argument concerning whether there was an international armed conflict on the facts of our case. We agree that an international armed conflict occurs where there is a resort to armed force between 2 or more states. This was the test that was affirmed by Trial Chamber 2 in the Katanga judgment at paragraph 1173. However, while the Government Council says that OSTY is not a state for these purposes, we submit that OSTY is sufficiently state-like for this court to be able to invoke the the laws and customs applicable in international armed conflict. Those are the words quoted from the chapeau of Article 8.2b. Now, to be clear, Your Excellencies, we are not suggesting that OSTY is a state at international law. In particular, we are not suggesting that OSTY is to be given the rights of statehood. All we are saying is that given OSTY's attributes, this conflict was effectively a conflict between two states, between OSTY and Taivosh, and that is sufficient for the laws of international armed conflict to apply, and one of these laws being Article 8.2b.4. I proceed.
So, and what you're saying, there's an indicia of statehood, of state-type conduct.
Mr. President, we rely on the Article 1 of the Montevideo Convention, which lays down 4 objective criteria of statehood. And this is custom, as was stated at paragraph 86 of the ICTY Trial Chamber 2004 Milosevic decision. Now, the first criteria relating to a permanent or a defined territory requires control of a certain area. It is not necessary that boundaries are strictly defined, and this is quoted from paragraph 96 of the Milosevic decision again. And we submit that here, given that OSTY is in control of the southern portion of Yankel and all of Taivosh after its annexation of almost all of Taivosh except Querth, there is a sufficiently defined population for the purposes of this requirement. Turning to the second requirement of my apologies, I realized I referred to a permanent population back then. What I meant was a defined territory. Now, turning to the second requirement of a permanent population, the relevant population need not require strict permanence. All that is required is that there is an effective establishment of a settled community. And this is again from the Milosevic decision at paragraph 97. Our submission is that the peoples in the territories that OSTY currently occupy are sufficient to constitute this permanent population. Turning to the third requirement of a government, an entity must possess a government or system of government in general control of its territory to the exclusion of other entities, quoted from paragraph 106 of the Milosevic decision. Now, we recognize that there is no direct evidence on the facts of a centralized administrative mechanism, for instance, that shows that OSTY is sufficiently has a government. However, we can infer that OSTY has this system in place from the fact that, first of all, it is in control of large swaths of territory spanning from the southern portion of Yankel to the whole of Taivosh, except Querth. And prior to that, at paragraph 4, it was able to launch a coordinated series of attacks to seize almost all the territory of Taivosh. This implies a high level of coordination, of planning, and of cooperation between different branches of an administrative machinery that OSTY possesses. And finally, turning to the final requirement of a capacity to enter into relations with other states, a state has such capacity where it possesses the independence to do so. Independence is when the state is not subject to the authority of any other state and thus able to make its own decisions. And here, as can be seen from the last sentence of paragraph 2, Yankel has stated that it has had difficulties dealing with the rise of OSTY. We submit that OSTY has the relevant independence for it to have the capacity to enter into relations, and these 4 requirements being fulfilled, OSTY is sufficiently state-like for this court to invoke the laws and customs applicable in international armed conflict. Turning to the widespread, long-term, and severe requirement. Your Excellencies, Government counsel raised the point that the long-term requirement here has to be measured in terms of decades, and we agree. But in our submission, this damage on our facts does rise to that level, at least at the relevant standard of proof of the present proceedings. The damage here, although the salmonella outbreak here only lasted for 3 weeks, it does not mean that the natural environment would be completely cleared of salmonella after 3 weeks. The natural salmonella is known to persist and thrive in the natural environment and in the intestines of animals indefinitely. It can also spark an indefinite cycle of infection and reinfection, and we submit there's a reasonable basis to believe that the long-term requirement here has been satisfied. In any event, Your Excellencies, the elements of crimes, element 2 under this crime provides that the attack was such that it would cause widespread, long-term, and severe damage. And so even if Your Excellencies find that the actual damage here does not rise to the relevant requirements, we submit that this court need not confine itself to the actual damage that has been caused. It can also examine the potential damage that could have been caused but fortunately didn't. In our submission, these 3 requirements have been cumulatively fulfilled, and in the interest of time, I propose to turn to issue 3. Concerning the request for Judge Hastie's...
However, one quick question here. So far, we've heard that in order to determine what Article 8 gives us in terms of these criteria, that we have to look into additional Protocol 1. Is there any other guidance that you could think of that we should be looking into, which would define the term of decades, whether it needs to be decades or not decades? So that would be very helpful. Thanks.
We are not aware of any other conventions or treaties, and we rely on additional Protocol 1 as well as the Geneva Conventions, because the Article 8.2b specifically refers to serious violations of the rules and of the laws and customs applicable in international armed conflict within the established framework of international law. And a substantial part of this established framework of international law comes from Additional Protocol 1 and the Geneva Conventions. Turning to issue 3. As a preliminary point concerning Government Counsel's standing to request for Judge Hastie's disqualification, the prosecutor has relied on a strict interpretation of the relevant article to say that Government Counsel is not able to submit a request for disqualification. And the prosecutor has cited the Katanga case concerning the disqualification of Judge Van den Weingert. We align ourselves with this position, but in all fairness to Government Counsel, there is a subsequent case, the 2015 Lubanga case concerning the decision on defense application for disqualification of Judge Dikomendi. At paragraph 34, this court, the plenary, opined that in the interest of fairness and to uphold the principle of impartiality, a strict reading of Article 41(2)b might conflict with the principle of the equality of arms. So in fairness to Government Counsel, we submit that this court may consider allowing Government Counsel to request for Judge Hastie's disqualification. However, even if they have standing to so request, we submit that a case cannot be made out on these facts. Now the prosecutor, sorry, if I may rephrase myself, Mr. President asked whether there is a distinction between academic writings as well as a judge's profession, which is to sit in a courtroom and decide on the facts whether a crime has been committed or whether the issue in question has been satisfied. Now, in our submission, just because a judge has opined on a certain matter, it does not necessarily mean that when that particular matter appears before that judge, Your Excellencies, if I may have 1 minute to complete my submissions. If I may quote from the Furunzia case at paragraph 202, and I quote, "To endorse the view that rape as a crime is abhorrent and that those responsible for it should be prosecuted within the constraints of the law cannot in itself constitute grounds for disqualification," because the quote that the judge would apply the law, would look at the facts within the constraints of the law, shows that judges are, even though they have written something before, this does not mean that they would be biased when looking at the facts presented before them. We submit that Judge Hastie need not be disqualified as there was no appearance of bias. Unless I may be of further assistance, this concludes my submissions. May it please the court.
Thank you. Well, I believe that important points have been raised in the statements made by each of the parties in this case and the participants, and each party will now then be given, in the same order, the possibility to reply to the arguments made by other parties. I would like to remind you to carefully respect the time allocated for this exercise. No team will be given more than 10 minutes for their rebuttal arguments, and I would ask the Government's Counsel to proceed, please.
Honorable Mr. President, distinguished judges of this court. In my rebuttal, I want to show in 4 points why the submissions of my learned friends and colleagues so far do not against the case we have brought forward stand. But at the outset, I want to make a remark very shortly on the fact that even though there might be an impressive display of case law on the side of our learned friends and colleagues, this court is not bound by such case law. Indeed, as Article 21, subsection 2 of the Rome Statute emphasizes, where even if there is precedent, the court may come to a different finding precisely because it finds that other arguments are more convincing than the precedent. But allow me at this point to start with my first point on the issues of organization that have been brought forward. Our learned friends from the prosecution have made reference to the fact that it is possible, or have argued, that it is possible to distinguish clearly between international core crimes and domestic jurisdiction using the concept that this court in its jurisprudence is applying. But allow me therefore then to point to the concurring opinion of Judge Ozaki in the Bemba case. Her opinion was that the concept used by this court leads to, bears with it, a high risk of circular reasoning. This is because it is very easy to infer an organization from the facts that those crimes have been committed if the only requirement is the capability. And therefore it is very necessary to have clear criteria and to clearly outline the entity that is the organization and why it is capable of doing so. And this brings me to the issues raised by our learned friends from the victims' representative on the question of a state-like organization. Very firstly, I would like to respond to the argumentum ad absurdum, apparently, regarding the tyrannical regimes that has been made. We submit that in these cases, if such regimes come to power through a coup, they would most likely be considered then the government of the state. Legitimate or not, they do exercise the powers of the government of that entire state, and therefore would fall under the category of state. And secondly, regarding the question or the submission that the authorities on our side are not clear enough, we submit that we indeed do not have a precedent decided by the majority of the case, but regarding our authority, we rely on the writings of eminent scholars such as Richard Vernon from Canada, David Lubin from the United States of America, or Professor Klaus Kress from Germany. And this brings me to the issue, or this leads me to re-emphasize that there is indeed authority and criticism of the court's approach that supports the submissions that we have brought forward to this court. And this leads me to the very interesting issue of an international armed conflict. My learned friends from the prosecution have submitted that there is an international armed conflict because the conduct of OSTY can be attributed to the state of Juncker. The first response to this is that they have made use, firstly, of the ILC articles on state responsibility, or generally of ILC statements. And we would like to remind this court that such statements are, important as they may be, made by professors and not by states. And therefore, they do not constitute state practice, and they do not show that there is an intention of the states to concur with the findings of the ILC. And then, even if the state responsibility rules found by the ILC existed in this form, they do not give rise to an international armed conflict. This attribution has no effect on the characterization of the conflict. And the reason is, as the ICJ found in the genocide case, the due diligence tests that allow for an attribution have no bearing on an international armed conflict, for which the only relevant tests are still the effective control or the overall control test. And then finally, on the attribution point, I would like to talk about the Lebanon report, or the case of Lebanon that has been raised by our learned friends from the prosecution and the Hezbollah. And in this case, the report by the Human Rights Commission at the UN General Assembly emphasized two crucial points that show that the case of Lebanon is very different from the case of OSTY. The first point they mentioned is that Hezbollah was a political party in Lebanon and does take part in state organs and is integrated deeply into the state. OSTY is no political party in Juncker, and indeed, as it cannot be emphasized enough, the state of Juncker is doing everything to fight this organization. And secondly, in the case of Lebanon, this report found that the people of Lebanon regarded the Hezbollah as the legitimate expression of their resistance against the Israeli occupation. There is nothing in that situation, and no one in Juncker who regards OSTY as a legitimate expression of any will of the people or of the states. And therefore, the president of Lebanon cannot be used as an authority or cannot have any bearing on our submissions. And finally, regarding what the Victims' Council, our learned friends from the Victims' Council, have said on the international armed conflict, we submit that there is no state practice that allows for the inclusion of states that are, or of actors that are short of being a state, or that are states in status nascendi, so to say. There is nothing that allows the inclusion of these actors. And on the question of the all mixed state of Tibor and Juncker being, in fact, a state, we would like to very quickly respond to this by pointing out that the criteria from the Montevideo Convention are indeed not met. And the most crucial criterion that is not met is the criterion of the capacity to enter into relations with another state that they have brought forward. Because posing a threat to a state does not mean that there's a capacity to enter into state-to-state relations. This would require an embassy, this would require diplomatic correspondence, or anything to that extent. And there is nothing that shows that OSTY has made such tries to enter into relations with other states. And therefore we submit that the Montevideo criteria are not met. And even if they were met, the Badinter Commission of the European Union has found that the requirements need to be met for a certain duration to ascertain that there is in fact a state. And as there is still a situation of conflict and hostilities in the situation in Porvos, it is not certain whether OSTY has met these criteria for a time long enough. And this leads me on a very quick remark on the issue of territoriality. If our learned friends from the prosecution submit that the crime, that conduct in Article 12.2a means crime, this still, Jonas, still includes the conduct that needs to be on the territory of the state's parties, as well as then the circumstances and the consequences. And this conduct has occurred on the territory of Juncker and not on Porvos. And then on the issue of long-term that our friends and colleagues from the victims' representative have brought up. They have agreed to our standard of decades that we have proposed. And regarding this standard, I would like to respond as follows, and please excuse the drastic way of this response, but there are salmonella everywhere in this environment. There are salmonella on every chicken that one can buy in every supermarket. So the issue is not whether salmonella will remain in the environment for decades. They are most likely already there. The issue, Your Honours, is the concentration of salmonella that actually causes this immense outbreak, and that is the actual damage and the crucial change to the natural environment. And this damage has only lasted for 3 weeks, and even if it would have lasted somewhat longer, there is, as I re-emphasize again, no outbreak known that lasted for decades. And as a final point on this issue, it has been found by the parties that wrote the additional protocol that the damage in World War I through the heavy shelling of the natural environment should not be sufficient to reach the thresholds. And as in the present case, there is far lower damage than this. The thresholds are also not met, Your Honours. And this brings me to my final point of rebuttal on the issue of the disqualification of Judge Hastie. And we would like to respond to this very quickly by firstly arguing that indeed the government of Juncker does have locus standi, does have the possibility to lodge such a declaration, such a motion for the disqualification of a judge. And the crucial reason for that is that the wording of the norm that they have brought up, the wording of the Article 41 that allows this disqualification, is worded openly. It does not contain the word only, those two parties, and it does contain the word may, and it does contain parties as an example from the trial phase. So therefore we submit that the parties from the pre-trial phase must also be included, and this application of the pre-trial phase parties to this article means that the government of Juncker does indeed have standing. And finally, I would like to very shortly respond to our learned friends from the prosecution who have argued that her wording was very modest. I would like to say that she indeed used the word heinous, she used the word scourge, and she expressed a strong opinion on this case, and she said that the ICC could have jurisdiction if there were a situation where jurisdiction arises, and therefore there's no hypothetical or modest wording on her behalf. And this, in total, concludes my rebuttal, and I again would like to ask this court humbly and respectfully to reverse the rulings of the pre-trial chamber and confirm, therefore, this appeal. Thank you, Your Honours, very much for your attention.
May I now ask the prosecution to now present its observations, again observing carefully the 10-minute rule.
Good afternoon again, Your Honours. I have 4 points of rebuttal in response to the arguments made by Government Counsel and Victims Counsel. My first point of rebuttal relates to the issue of widespread, long-term and severe damage to the natural environment. Both the Government Counsel and the Victims Counsel have interpreted the requirement of long-term to be one of decades. To do so, they have relied on the additional Protocol 1 to the Geneva Convention. However, we submit that the more appropriate treaty is the Environmental Modification Convention, or the ENMOD Convention. And this is because it is widely regarded that the additional Protocol 1 standard is far too high and far too stringent to be of any practical purpose. In fact, the United Nations Environment Programme specifically noted that the additional protocol standard is nearly impossible to satisfy. Therefore, we submit that for an effective interpretation of the Rome Statute, the ENMOD standard should be applied. The Environmental Modification Convention defines long-term as a period that is capable of measurement in months. We submit that that requirement has been met in the present case. The Salmonella bacterium is known to be capable of surviving in freshwater for a period of up to 4 months. While the Government Counsel argues that in this case, the outbreak only lasted for 3 weeks, we submit that that is the outbreak of illness. What we are concerned with in the present case, and what Article 82b4 is concerned with, is damage to the natural environment. And we submit that the Salmonella would continue to exist in the water body for a period of up to 4 months, and therefore would satisfy any requirement of long-term damage. Proceeding to my second rebuttal, the Government Counsel argued that if only the requirement of capability to commit widespread or systematic attacks were to be the criteria used for organizations under Article 7.2a, then it would result in circular reasoning. However, we would clarify that that was never our submission. In fact, the most important criteria for an organization to be able to commit crimes against humanity, as per the Kenya decision, is that of de facto control over territory, and that is present in the present case. In fact, this test has been followed repeatedly by this court, most recently in the authorization for investigation into Georgia, and therefore we submit that OSTY does fulfill all requirements for an organization. My third point of rebuttal is concerned with the issue of an international armed conflict. The Government Council argued that the standard of due diligence has no relevance before this court and that the only test that this court should apply is that of overall control laid down in Tadic. We submit that the case of Tadic can be distinguished from the present case. In Tadic, what the court was concerned with is the support of a state, in that case the Federal Republic of Yugoslavia, to a non-state actor, which was Republika Srpska, acting outside its territory in the state of Bosnia. However, as the International Court of Justice has noted in the Corfu Channel case, there are certain additional obligations that states have with respect to private actors within their own territory, and one of these obligations is that of due diligence. Therefore, we submit that the test of due diligence can be used. In fact, in Tadic, the court noted that while determining the rules of attribution for the purposes of an international armed conflict, the rules on state responsibility could be applied by a court. And we submit that according to the ILC's commentary on the Articles of State Responsibility, a failure to comply with due diligence obligations is one of the methods of attribution of conduct. Finally, the Government Council has argued that Juncker is repeatedly making its best efforts to restrain OSTY, and therefore the conduct of OSTY cannot be attributed to Juncker. We submit that this is incorrect. Paragraph 2 of the facts states that there has been a United Nations High Commissioner for Human Rights report in 2014 which found that Juncker has a weak and corrupt government that has been both unable and unwilling to control OSTY's growth, and therefore we submit that OSTY's conduct can be attributed to Juncker. Which brings me to my final point of rebuttal, which concerns the disqualification of Judge Hastie. The Government Council argued that Article 41(2)b should be given an expansive reading, since it never uses the word only, but only the word may. We submit that this is incorrect because, as we stated earlier, this court in the Katanga case, while ruling on the disqualification of Judge Wingart, stated that Article 41(2)b had to be constructed in a strict manner and that only those parties specified in that provision and no others would be entitled to request disqualification. Finally, the Government Council referred to the use of the words heinous in Judge Hastie's opinion to indicate that her opinion was not a moderate one and rather was a strong one, and therefore she should be disqualified. However, I would like to point out that the use of the word heinous was in relation to the act of juvenile piracy or recruiting juveniles for the purpose of piracy, and not to her legal opinion that the recruitment and use of juvenile pirates could be tried as a crime against humanity. And we submit that there is a difference between the two. As the ICTY noted in paragraph 699 of the Celebici case, a reasonable observer would not expect judges to be morally neutral about crimes against humanity, such as torture, rape, or crimes against children. Rather, such a reasonable observer would be aware that judges are to be of the highest moral character and therefore should condemn such actions. Moreover, in an identical case before this court, which is the prosecutor versus Katanga, Judge Song used this exact word, heinous, to describe the practice of recruiting child soldiers. And in that case, he was to try Mr. Thomas Katanga for the recruitment and use of child soldiers. Nonetheless, the court did not disqualify Judge Song because the use of the word heinous was in relation to the act of recruiting and using child soldiers, but not with respect to the party before him or with respect to a legal opinion. Similarly, we submit that Judge Hastie should not be disqualified, as the use of the word heinous does not reflect on her legal opinion. If I may be of no further assistance to this court, I thank this court for its time.
Now, the last word is to the legal representative of victims, who has the floor. Thank you.
Mr. President, Your Excellencies, 4 points in Sir rebuttal. The first concerning the existence of an international armed conflict and our reliance on the resort to armed force between 2 or more states test. Second, relating to the conduct in question with respect to issue 2. third relating to salmonella contamination, and finally relating to the use of the words heinous and scourge in Judge Hasty's prior publication. Now, Government Counsel argued that there is nothing in state practice to show that international armed conflict can exist between a non-recognized state and a recognized state. However, this is not true. In the case of the 2004 Milosevic decision before the ICTY, in that case, the ICTY applied the laws of international armed conflict even before Croatia was recognized by the European community and even before Croatia was recognized by the United Nations. Croatia, as a new state, though not recognized at law, was able to resort to armed force was able to satisfy the test for an international armed conflict between two or more states. Government Counsel further argued that OSTY does not have the capacity to enter into relations with other states. However, as stated in the Montevideo Convention, the words expressly are the capacity to enter into relations, not legal relations. So the truth of the matter is that all this court needs to apply its mind to is whether, as a matter of fact, OSTY is capable of entering into relations with other states. And this ultimately boils down to a question of independence, as was stated in the Milosevic decision. And in that case, the ICTY inferred that used the fact that Yugoslavia no longer had control over the relations of Croatia to find that Croatia had the relevant capacity to enter into relations with other states. Now, on our facts, at paragraph 2, at the last sentence, as has been earlier canvassed by the prosecutor, Government Counsel has stated, or rather Yanko has stated, that it has had difficulties controlling OSTY. OSTY therefore has the relevant independence necessary for it to have the capacity to enter into relations with other states. Turning to my second point in Sir rebuttal concerning the conduct in question for the contamination of Mirror Lake. Government Counsel's chief argument is that the conduct in question merely relates to the release of salmonella from the Yanko side of the border. However, this is an extremely narrow and self-serving definition because conduct in our submission involves the contamination of Mirror Lake, and this conduct spread across until it occurred on the territory of a state party, that of Porvos. And this is the interpretation this court should apply because on the facts of our case at paragraph 9, Yanko intentionally wanted this to be the outcome. They cannot thereby hide behind mere technicalities to say that this court has no territorial jurisdiction. Turning to the contamination and the prosecutor's reliance on the NMOD definitions. Again, as I've pointed out earlier, while if this court were to accept the NMOD definitions, we would be glad to follow this as well. However, we note that the difficulty here is with the fact that Article 82B has to be within the laws, the established framework of general international law. But even if we take Government Counsel's definition of the long-term requirement, we submit that this requirement is satisfied on the facts. Government Counsel's argument is that salmonella occurs everywhere. It is a naturally occurring bacterium, and that therefore it cannot constitute long-term damage. However, Your Excellencies, cyanide is a naturally occurring poison that exists in peach pits. If cyanide were to be dumped in unnaturally huge concentrations into a river, surely that must amount to damage to the natural environment. And here, salmonella was released into the rivers in unnaturally huge amounts, which resulted in 3,000 hospital visits and 50 deaths. turning to my final point in Sir rebuttal concerning Government Counsel's argument that the use of the words heinous and scourge sufficiently show an appearance of bias. Now, as Government Counsel and the prosecutor has stated earlier, there is basis to disqualify a judge where a reasonable observer, properly informed, would reasonably apprehend bias. And this finds authority in this court's 2012 Banda Gerbo decision concerning the defense's request to disqualify Judge Chile Iboe Osuji. However, it has to be further stressed that such a reasonable observer is objective, is pragmatic, not overly sensitive, and ultimately has regard to the nature of a judge's profession. And the nature of a judge's profession is that a judge typically would be well published, and this is because for a judge to be elected to the bench of the ICC, the judge must possess the relevant qualifications under Article 36(3)(b). So in our submission, this publication on its own is not sufficient to show a reasonable appearance of bias. And if I may refer Your Excellencies to a case where there was a successful disqualification so as to show how that case can be distinguished from, how that case satisfied the high threshold necessary to rebut the presumption of impartiality. And I refer this court to the case of the disqualification of Judge Robertson before the Special Court for Sierra Leone in the CICE case. Now, Judge Robertson had written in a prior book that the members of the Revolutionary United Front, and I quote, were programmed to kill and pillage and mutilate, and that the members of the Revolutionary United Front were guilty of atrocities on a scale that amounts to crimes against humanity, unquote. Now here, these words show that Judge Robertson had prejudged the very issue before him, His Excellency, because His Excellency was to hear the issues concerning the criminal responsibilities of individuals of the RUF before him. And so in those circumstances, a reasonable observer, properly informed, would apprehend bias from the fact that the judge had prejudged the issue. On our facts, the fact that Judge Hastie used qualified language, such as the word could, such as the word may, does not rise to the level that would be necessary for a disqualification request to succeed. Unless I may be of further assistance.
Thank you.
This concludes my Sir rebuttal. May it please the court.
Well, the bench will now leave the courtroom to proceed with our deliberations in our chamber. Of course, you are permitted to leave the courtroom, but can I ask you all to be present in order to recommence at 16:10 by that clock. Thank you.
All rise.